Good morning, good afternoon, good evening. Welcome to the webinar Business, Human Rights and the Human Right to Water. My name is Mara Tignino and I'm a reader at the Faculty of Law and the Institute for Environmental Sciences, the University of Geneva, and lead legal specialist at the Platform for International Water Law at the Geneva Water Hub. This is the second webinar organized in the context of the e-learning course on international water law and the law of transboundary aquifers developed by the Geneva Water Hub and the University of Geneva. Today, we have the pleasure to have two specialists in the area of business and human rights from different perspectives. Professor Angelica Bonfanti, who is Associate Professor in International Law at the Law Faculty of the University of Milan, and Professor Roberta Greco, who is Adjunct Professor at LUMSA University, Rome. Their presentations will be complementary in addressing the relationship between business, human rights, and the right to water. Professor Bonfanti will focus on the UN Guiding Principles on Business and Human Rights, UNGPs, and the right to water. The UNGPs have turned 10 years this year since their unanimous endorsement by the Human Rights Council in 2011. As indicated in a recent UN report, the UNGPs are a globally agreed authoritative standard for states and private companies and indicate how to ensure and protect the whole range of human rights across all business contexts. This is something which did not exist before 2011 and show us the key role of this instrument in providing a framework and the key terminology in framing the responsibilities of private actors, including in relation to the right to water. One of the key features of this instrument is the recognition of the principle of corporate human rights due diligence. This principle requires that the private companies have the duty to identify, prevent, and mitigate their adverse impact on human rights. Professor Bonfanti will explain us the key features of this corporate duty. In the second presentation, Professor Greco will deal with the human right to water and international investment law. She will give some examples on how arbitration tribunals have solved disputes between states and private actors and the role of the right to water in these awards. Several arbitration tribunals have dealt with the cases of privatization of water services, especially in South America, but not only there. And in this context, one of the first cases, if not the first one, was related to the privatization of water services in Cochabamba in Bolivia. This case was brought in 2001 before an arbitration tribunal of the International Center for the Settlement of Investment Disputes, ICSID, and the claimant, the private company Aguas del Tunari, argued that the rescission of the concession contract by Bolivia amounted to a breach of various provisions of a bilateral investment treaty between Bolivia and the Netherlands. While this dispute was solved outside the tribunal with an agreement between the private company and Bolivia, and the private company withdrew any financial claims against Bolivia, there are other cases which will be explained by Professor Greco, which ended with a financial compensation to the private company. I would like to underline an interesting element of these investment disputes related to water, that is the participation of civil society groups through the submission of amicus curiae brief by non-governmental organizations. This brief underlines the impact of investment disputes on the human rights of local communities. Before giving the floor to our speakers, some housekeeping rules. Please mute your micros and you can write your questions in the chat box and we will address them during the Q&A session. I would like to conclude this introduction by thanking Professors Bonfanti and Greco to be with us today, and I pass the floor to Professor Bonfanti for the first presentation. Thank you.
Thank you very much. Thanks very much to Professor Maratignino for her kind invitation. I'm very happy and honored to be here and to share with you some ideas and reasonings about business human rights and the human rights order. So I have prepared a PowerPoint presentation that I would like to share. So I do it. That's my presentation. So within my short speech, as Professor Tignino has already announced, I will deal with the international legal framework on business and human rights, and I will make a specific reference to the relationship existing between corporate activities and the protection of the human rights order. In this regard, I will focus on a specific duty that is currently, the introduction of which is currently under negotiation at the United Nations in the European Union context, the so-called corporate duty of human rights due diligence. And so we will discuss about its usefulness as to prevent and remedy the occurrence of abuses in the field of specific attention today. So as already anticipated by Professor Tignino, the UN Guiding Principles represent the main leading instrument in this field. They were adopted by the United Nations, the UN Special Representative of the Secretary General of the United Nations in 2011. And even though they are a soft law instrument, therefore they are not legally binding, they are the leading instrument because of the fact that not only they have been endorsed by the United Nations, but they are unanimously recognized as an authoritative instrument and as a leading instrument in this field by the civil society, the non-governmental organizations, and the corporations themselves. So the main positive outcome of the UN Guiding Principles on Business and Human Rights is that they have clearly addressed and reconstruct the legal principles in the field of the regulation of corporations and human rights protection. And in so doing, they have represented the model for the development at a domestic level of consistent legislation, as we will see, and also represented the model for the future development of international binding instruments in this field. Thus, let's see a little bit what these UN Guiding Principles on human rights focus on. Basically, they provide for 3 pillars. The first one is the state duty to protect human rights. And it is a very, let's say, classical principle of international law. States, as we know, are bound to protect human rights. When we refer to the corporate activities, the human rights at stake are basically all the fundamental human rights recognized at the international law level by the main international legal instruments, thus including the Universal Declaration of Human Rights, the United Nations Covenants on Civil and Political Rights and Economic, Social and Cultural Rights, and the main International Labour Organization conventions. Therefore, obviously, the human rights order is one of the main rights covered by this instrument. Then the second pillar is the most innovative one, the most innovative pillar of the UNGPs, which is the acronym of United Nations Guiding Principles, insofar as the UNGPs recognize the so-called corporate responsibility to respect human rights. The corporate responsibility is something innovative at the international law level, since the international subjectivity of corporation is still under discussion. And so for the first time, the UNGPs recognize that corporations have to respect the international human rights and are responsible in case of lack of compliance with them. Moreover, the UNGPs indicate a specific tool that corporations should put in place in order to respect human rights. This tool is the so-called human rights due diligence. The human rights due diligence is a process according to which the corporate actors should map their supply chain, so identify precisely which are the subsidiary companies and which are the contractual partners involved in the supply chain, and map the human rights, the impacts, effective or potential on human rights that their activities throughout the supply chain could cause. Once identified the risks on human rights throughout the whole supply chain, the corporation should adopt the necessary preventive measures to prevent the occurrence of abuses and the necessary remediation measures in case those abuses nonetheless occur. Therefore, the most innovative aspect of this process is such a coverage of the whole supply chain and the mapping of the risks, also of the potential risks on human rights, the prevention and the remediation of them, in full cooperation, in full consultation with the involved stakeholders. Therefore, the identification of the risk should be the most effective one, insofar as the affected stakeholders should be involved in the identification and remediation phase. Now, which is the relationship existing? And the first pillar, I'm sorry, just briefly, instead concerns access to remedies. Therefore, states and also states should introduce the necessary judicial remedies for corporate abuses, but also non-judicial remedies are taken into consideration, such as the national contact point of the national contact point for the implementation of the OECD guidelines for multinational enterprises, which are another soft law instrument, this time adopted by the Organization for the Economic Cooperation and Development, the aim of which is to identify standards of conduct for corporations also in the field of human rights compliance. And each adhering countries to the OECD guidelines has a national contact point in place. For instance, I will talk a little bit of the instances subjected to the Italian national contact point, which is a non-judiciary body established within the Ministry for Economic Development. And the OECD national contact points adopt statements, non-binding statements that are mainly the outcome of a conciliation procedure. So they are non-judiciary decisions, the practical effectiveness of which nonetheless is relevant. Now, which is the relationship existing between this legal framework, the regulation of corporate activities, and the human right to water protection? I have identified three main sectors where the corporate activities can negatively impact on the respect and the protection of the human right to water. So first of all, I will focus on the activities of the large-scale water-using companies. Then I will address the activities of the large-scale water-polluting companies. And then I will have a specific focus on the hydropower projects and the construction of dams. So the first problematic relationship existing between the development of corporate activities and the protection of the human rights to water concerns the so-called phenomenon of water grabbing, which is the phenomenon according to which corporations acquire large portions of land and of the water flowing through these lands for the development of their economic activities. Some scientific reports state that the water grabbing by corporations amounts to more than 450 billion cubic meters per year globally, which is a very huge amount, and that they mainly involved investors originate from 7 countries, the United States, United Arab Emirates, India, United Kingdom, Egypt, China, and Israel. And their economic activities are mainly developed in the field of agricultural, biofuel, and timber investments. Therefore, with these large consuming water consuming activities, these investors and these corporations can negatively impact on the access to water by the local communities and consequently negatively infringe their human right to water. Then there is another issue with the large-scale water polluting companies, which are companies whose activities can negatively impact on the right to water insofar as they pollute the water and thus make it less accessible, the clean water to the local communities. Here, I would like to refer to two examples solved, the first by a judiciary body and the second one by a non-judiciary body. The first one was solved in the merits by the Netherlands, the Dutch Appeal Court of Appeal in January 2021. The case concerned the responsibility, the tort liability exactly of Shell for the environmental damage and the consequent human rights violations caused to some farmers in the Niger Delta. And the court recognized that both the Shell parent company, so the Dutch parent company, and the Nigerian subsidiary company are responsible for such human rights violations. The polluting activities of the company in Nigeria clearly impacted negatively and also the human rights to water of the plaintiffs. The second case instead was settled by the Italian National Contact Point for the monitoring and implementation of the OECD guidelines on multinational enterprises, the non-judiciary body I referred earlier. And the case concerned the construction of infrastructures by the Italian gas company ENI in Ethiopia. This construction determined the floods of the rivers with consequent negative impacts on the local communities due to the blockade of the stream of the rivers caused by the infrastructures themselves. Activity, the conciliation led by the OECD national contact point, Italian national contact point, led to the conclusion of an agreement between the company and the complaining party for the construction of drainage solutions by the company itself in Ethiopia. Now, the third case I would like to mention concerns the hydropower projects. The non-governmental and the intergovernmental reports acknowledge that the construction of dams can negatively impact on the respect of several human rights, including the right to water of the local communities. And the same conclusion was reached by the Italian national contact point in a recent case brought and settled against Salini, an Italian company. The case was brought to the attention of the national contact point by Survival International and a non-governmental organization, concerned the construction of the Aquifers Dam in the Omo River. The river runs from North Ethiopia to Kenya, with the consequent destruction of the livelihood of the local community due to the deprivation of water. The national contact point recommended to Salini provide the technical support to mitigate this issue and to use its leverage to grant the compliance of its activities with the United Nations guiding principles. So we close the circle, let's say. So which are the solutions? Few remarks on the solutions I propose to all these negative impacts and all these, let's say, unfavorable relationship existing between the development of economic activities and the protection of the human rights to water. I suggest that the provision for the corporate duty of human rights due diligence would be a good solution or an effective solution, let's say. And so I hope very much that the human rights due diligence will be provided as an obligation for corporations. Actually, we are going exactly in this direction since after the adoption of the UNGPs, several states have provided at the domestic level for legislation in this direction. I explicitly make reference to the French law on the devoir de vigilance, but also to the recent legal initiatives adopted by Germany, for instance, while the Netherlands and UK had already in place specific legislation, respectively, on child labor and forced labor, so more limited. But similar initiatives are already in this moment currently under the attention of the United Nations and the European Union. The United Nations, in fact, is currently negotiating the adoption of a treaty, so a binding instrument for the regulation of the corporate activities in human rights law. And one of the main outcomes of the adoption of this treaty would be the introduction on the contracting states of the obligation to establish the corporate duty of human rights due diligence for their corporations.
Many thanks, Angelica. It was a very enlightening presentation about the key feature of the corporate human rights due diligence, and also you gave us relevant examples to illustrate with concrete examples this duty. So now I pass the floor to Professor Greco for her presentation. Thank you.
Good morning everybody, and thank you, Professor Tinino, for this kind invitation. And thank you to the students of this learning course for your participation. My presentation will focus on the current and potential role of the human right to water in international investment disputes. I will consider disputes in which the ability of state to terminate concession contracts or to adopt regulatory measures affecting foreign investors was at stake. I will not address the content and status of the human right to water in international law, because for this issue I refer to the lesson I have registered for this learning course. Instead, I will briefly mention my conclusion during this registered lesson on my conclusion on the impact of the human right to water in international investment disputes concerning the privatization and liberalization of water services. This preliminary reference would allow me to make a comparison between investment disputes concerning water services and investment disputes regarding other industries likely to affect the enjoyment of the right to water by degrading the water quality and also the surface water and groundwater resources. Therefore, in this presentation, I will consider two sets of investment disputes, one concerning water services, the other concerning other industries. In the first set of investment cases concerning failed privatization and liberalization of water services, investment tribunals have sought to find a balance between different interests at stake. Those of investors, the interest of investors and the interest of the affected population. In this case, foreign private companies had invested in the water services sector mainly in Argentina, and claimed to have been expropriated of their investment due to a number of regulatory measures adopted by Argentina to protect people's access to water services. These measures had modified the regulatory environment which existed at the time the investment was made. And I make some examples. For instance, among these regulatory measures, we can mention the prohibition to disconnect poor households from the mains in case of arrears of payment, or the prohibition to raise water services bill. Now, following the 2002 economic crisis, Argentina was requested to comply at once, at the same time, with obligations owed toward investors in pursuance of the bilateral investment treaties Argentina was a party, and at the same time to comply with obligations owed towards its citizens under the human right to water. In this context, when Argentina claimed to have adopted regulatory measures to comply with obligations to respect the human right to water. And I'm referring to the case I have mentioned in my lesson, that Suez versus Argentina, South versus Argentina, and Urbaser versus Argentina. In these cases, arbitrators took this argument, this human rights defense into consideration in establishing whether there had been breaches of the bilateral investment treaties. In particular, arbitrators resorted to a systemic interpretation of the BIT's provisions in order to take into account states' obligations stemming from the human right to water. They also referred to the police powers doctrine, according to which states possess the right to regulate in the public interest and do not act wrongfully if they exercise their power to adopt bona fide, non-discriminatory, and proportionate measures. In the Suez case, the ICSID tribunal rejected the investor's claim of expropriation, arguing that the measures taken within the state's police powers are not expropriatory in nature and give no right to compensation. In the Saur decision, the tribunal affirmed that while the exercise of police powers can amount to a regulatory expropriation, however, state may be exempted from paying compensation unless otherwise established by BIT provisions. And finally, the most important case maybe is Urbaser, in which the tribunal granted priority to human rights consideration over investors' interests. In particular, the tribunal interpreted the investors' expectations as including also the consideration that states bear the duty to protect the access to water for their population, and affirmed that the obligation to protect access to water may trump conflicting investors' rights. Therefore, we can conclude that the right to water has impacted on the tribunal's decision on the merits. The same conclusion cannot be reached for the second set of cases concerning investment made in industries different from water services, but likely to degrade freshwater and groundwater resources. In the case, in well-known case, Metanex versus United States of America, the state of California banned the sale and use of gasoline, of a gasoline additive named MTBE, and due to concern that this additive had contaminated the state's freshwater resources, concern that its production posed environmental threat to groundwater and drinking water and jeopardized human health. Metanex will be damaged by this ban, as it was the world's largest producer of methanol. Methanol is a feedstock for MTBE, the additive banned. Metanex claimed that the ban on MTBE had instead an illegitimate aim, the aim to favor the massive producer of ethanol, another component of gasoline. In other words, according to Metanex, the intent of California was to discriminate against foreign investors in favor of domestic ones. In this case, the tribunal granted leave to file a written submission to some NGOs. So the Amici Curiae, Professor Tinino mentioned before. And among these Amici Curiae and these NGOs, there was a Blue Water Network. And in their submissions, the NGOs contended that the tribunal had to evaluate evidence concerning Californian intent in banning MTBE in light of the government duty to protect human rights and the environment. Reference was also made to the the obligation of California to protect the human right to water. Another NGO, the International Institute for Sustainable Development, also was granted leave to intervene, and it contended that Chapter 11 of NAFTA, the North America Free Trade Agreement under which the investment was made, should be interpreted in accordance with the general principles of international law, and for this reason, should not impact the right to regulate of states. The tribunal, according to this NGO, should have dismissed the notion of regulatory taking. This is a tricky notion because according to it, a regulation that protects public interest may, however, cause an expropriation that must be compensated if it caused the diminution of the economic value of the investment made prior to such a regulation. The tribunal dismissed Methanex's claim, stating that California ban was made for public purposes and was therefore a lawful regulation and not an expropriation or a measure tantamount to expropriation. But what is interesting in this case is the reasoning of the tribunal, according to which Methanex has not received any assurances from California. On the contrary, Methanex entered into a political economy in which it was widely known, affirmed the tribunal, that governmental institutions monitored the use and the impact of chemical compounds and commonly prohibited the use of those compounds for environmental and health reasons. In other words, the tribunal underlines the importance granted by California to environmental and health issues and stated that the investors should have expected that. So these politics should have shaped the investors' expectations. We can conclude that the tribunal took into consideration public interest, the public interest that underneath Californian ban, but it did not refer to the human right to water, although it was mentioned by the Amici Curia. The other case I want to analyze is the Pakrim Cayman LLC versus Republic of El Salvador. This is a case which concerns a gold mining concession. On March 2008, the president of the Republic of El Salvador declared a de facto ban on all metallic mining projects in El Salvador. An investment claim was then raised by a Canadian mining company, Pakrim, that since 2002 had invested millions of dollars in mining exploration in El Salvador. The company, in fact, had acquired licenses rights to conduct exploration work in the area of El Dorado in El Salvador. These works were necessary to prepare an application for a gold mining concession. According to the company, in making this investment, the company relied on the state legal regime for investment, which was issued that framed their expectation, in addition to governmental assurances. The de facto ban on mineral mining, according to the investor, nullified the previous regulatory regime, and in particular the El Salvador investment law. On this law, the investor relied in making its investment, so it was claimed. The company claimed to have had its investment destroyed, and it asked compensation for more than $300 million US. According to El Salvador, on the contrary, the company's rights under the exploration license expired due to the failure by the company to comply with the mining law, the national mining law. Also in this case, the tribunal admitted Amici Curiae submissions. This submission came from the Center for International Environmental Law with a coalition of 6 communities and other organizations. In its written submission, the Center for International Environmental Law contended that the measure adopted by El Salvador regarding the El Dorado project would have a negative impact on the enjoyment of human rights of the locals. In this connection, reference was made to a report issued by the International Union for the Conservation of Nature and prepared by Professor Steiner, which provided an examination of the context and consequences of the El Dorado project. According to this report, in 2004, and I quote, people living near mining exploration activities began to notice environmental impacts of mineral exploration, such as reduced access to water, contaminated water, impacts on agriculture, and health problems. In fact, most of the population opposed the mining projects due to the risk such project posed to the scarce water resources of the territory, and it was contended that the negative effects felt by the people in this stage would be even worse if the El Dorado project were to be developed. In the end, the tribunal dismissed the company request for compensation, but on grounds, once again, different from the human rights obligation of El Salvador. Now to conclude, from this case law, we can conclude that why investment disputes concerning water services, while in this dispute the right to water has been invoked by the respondent state to justify breaches of the BIT and was taken into account by arbitral tribunal in other investment disputes, likely to worsening the quality of water and groundwater resources, the right to water has not played any role. Governments have failed to address the impact of other industries on the enjoyment of the right to water, and have failed to underline the related obligation of state to prevent infringements of this right. Although the Amici Curiae have emphasized the interconnection between environmental degradation of water resources and the right to water, as well as the state obligation in this respect, the tribunal have not considered their legal arguments. So, what can we say? That given that the human rights defense has proven to be promising in investment disputes concerning water services, we can argue that this lack of understanding of the interconnection between environmental degradation and human rights weakened both the governmental defense and the arbitral tribunal reasoning, in which insufficient attention has been paid to the intersection between investment law, human rights, and international environmental law. Just to quote the European Parliament last report on the impact of large-scale agriculture and industry on the water, on the human right to water, according to the European Parliament, overall, the outcomes of tribunals, investment tribunals, have provided limited insight on measures states can take to respect and protect the human right to drinking water in situations where international investment agreement exists. Thank you for your attention, and I remain available for any questions.
Yeah, many thanks, Roberta, for this excellent presentation. You gave us a very good overview about the different case law regarding water services and other economic activities that can have an impact on the right to water. So now I leave the floor to the questions. Maybe I have a first one that I can read. So it is from Frank, or maybe Frank, would you like to take the floor and share directly your question?
Yes, Professor, thank you very much. I wanted to say excellent presentation. This time I can add Professor Greco, but also Angelica Confantini for the presentation. I am in a country where the human right to water and sanitation is not in our constitution, and I think a number of other countries are in that state. And so this right is not enforceable in our courts of law. And yet within our environment, we have these multinationals in the mining, dam construction, biofuel, timber production that have been seen to abuse this right. And so I wanted to get a comment from Professor. Of course, you have shared the developments that are happening in the European space in terms of what's happening in the legislation that is developing in the European Parliament and the UN in terms of those guiding principles. But what can communities in such circumstances do right now in places like ours, where this is already happening, despite the fact that we do not have this right already enforced in our constitution? Thank you.
Thank you.
So, thank you, Mr. Ioni, for your question. It's a very good question, actually. Let's say that I see two main solutions. The first one is concerns the specific, it depends very much on the specific corporate structure of the corporate actor involved. Because if it is a multinational corporation and the violation is currently put in place by the subsidiary company operating in Zambia, but the parent company is constituted and based in another country, the legal system of which recognizes the right to water, the best solution would be to bring the case before the court of the state where the parent company is based. Actually, this solution would be the preferable, not only because that system of law recognizes the right to water, but also because bringing the case against the parent company might grant the possibility to have the compensation order enforced, and thus would be much more profitable from the economic point of view and much more satisfactory and fair from the legal point of view. While the second solution, that is a very international law solution, and that would be let's say available also in case the abuses are put in place by local communities, to bring the case. I don't know, I was trying to check, but I did not have time enough to check whether Zambia is a contracting party of the UN Covenant on Economic, Social and Cultural Rights. The Covenant recognized the right to water, and so one solution would be to bring the case to the attention of the Committee on the Economic the covenant, the committee of on the economic, social, and cultural rights, that is the monitoring body of the United Nations Covenant, and does also individuals or interested groups such as NGOs could bring the case to the attention of the committee in order to have the state directly addressed with recommendations in this area. The observations of the committee are non-binding, which is something remarkable. So not necessarily would lead to the inclusion of the right to water with a binding. I mean, it is not a judicial body, so the effectiveness is not the same as a judicial court. But nonetheless, it's a very authoritative body, and this might be something very useful in this field. Finally, I don't know how Zambia adapts its legal system to international law, but I presume that if Zambia is part of, again, is a party of the Covenant on the Economic, Social, and Cultural Rights, the fact that the domestic legal system does not explicitly recognize the right to water does not preclude the recognition of the right to water as part of international law and of the binding obligations of the state. Therefore, the Constitutional Court might directly recognize the implementation, the Zambian Constitutional Court might recognize the implementation of the right to water as one of the principles established by the international law and one of the obligations on Zambia, regardless of its explicit recognition by the Constitution.
I have checked, and Zambia is not part of the optional protocol to the economic, social, and cultural
this
rights.
Makes
this is a
much more troubling. So you have to pursue either the first solution against the foreign companies or the Constitutional Court. I mean, you can bring the case to the attention of the Constitutional Court for lack of implementation of your substantive obligation of international law, including the right to water as part of international law.
Thank you. Yeah, we have another question from a colleague from Sudan. Please, you can take the floor. Thank you.
Mara, and we are enjoying your interventions in the course there, as well as thanks to the presenters for this actually extraordinary presentations. And I would like to thank Monica as well for also helping us with getting involved in this very important webinar. I think there are a lot of information that we really enjoyed. However, because we are not of a legal background as such, but it's opened our eyes to many things. I just wanted to mention that in our in sub-Saharan Africa, where I came from, I mean, you know that in the rural areas. Exactly where I came in, there are millions of people and so many people in they're sharing this water with sometimes with other animals, and sometimes it's pathogens, and I mean and we know that Sudan is not still party to the optional protocol, but we're looking forward to have that. Yes, my question is that what are the advantages that we are going to get if we join the optional protocol? I know that you, Greco, you just mentioned something in heads ups, but if you just go deeper into this, it would be very much appreciated. The other issue is we are seeing that only the NGOs who are like most of them are active in the issue of clean water. And please correct me if I'm wrong. I am not sure if the international organizations are like also have providing like funding or anything in order to help states to get clean water, or it's just because sometimes the contentions are there, they are very strong, and even if you can also get it in your national legislations, but I'm not sure if it is binding and it will help these countries in order to get access to clean water. Thank you very much indeed.
As far as the optional protocol to the International Covenant on Civil and Political, on Economic, Social, and Cultural Rights, if you ratify this protocol, you give the possibility to a person within your jurisdiction and NGOs to submit communications to the Committee on Economic, Social, and Cultural Rights, and this committee can issue views after a proceeding that is quite similar to a judicial proceeding. The committee can issue its views, which are not binding, but however they are uploaded to the UN website and are widespread recognition because they reached all countries. And I have also thought to another possibility, but this is in as a last instance possibility, but for the Committee on Economic, Social, and Cultural Rights would be the same, because before submitting a communication to the Economic, Social, and Cultural Committee, you have first to exhaust the local remedies. So you have first to go towards all national courts and until the Supreme Court, and then you can submit a communication to the Committee on Economic, Social, and Cultural Rights. And the other possibility I was thinking about is to ratify the optional protocol to the African Charter on Human and People Rights, because I was thinking that in such a way, after having exhausted all local remedies, you can you give the possibility to people and organizations, NGOs, to submit the communication, but in this case, the court will issue a binding judgment. As for the funding of projects to provide clean water, this is a huge problem, because for what I have studied, there is a customary human right to water, but the extraterritorial application of the human right to water is much contested. And the obligation to fulfill and to provide funding to other countries in order to reach, to foster the human right to water is contested by Western countries overall. So this is still a huge problem, I have to admit.
Thank you. Are there any questions? Just we have for time for one more question. No. So maybe I cannot resist to make also a comment I think that the option to go to regional human rights system, it is also as Roberta underlined the ratification of the optional protocol in the African regional system, but I think also that we should remind that courts, tribunals, also non-judicial bodies, they can do if also there are good arguments behind to interpret in a systematic way the applicable law. And for example, even if there is not the right to water included in the Constitution, or even if the African Charter does not include explicitly the right to water, this does not preclude the fact that the judges or members of the members of the committee can make reference, for example, to the UN General Assembly resolution or the Human Rights Council resolution to say, but we have a global recognition of the right to water. And indeed, for example, if you look at the case law of the Inter-American Court of Human Rights, even if the Inter-American Charter does not include explicitly the right to water, and the states were not party to the San Salvador Protocol, the judges were able not to say that there was a violation of the right to water and even of the right to life before because of the lack of water of indigenous communities. So I think that also this aspect should be reminded that we have also a global recognition of the right to water, and this can be used also in proceedings at the domestic level, at the regional level, and at the global level. So many many thanks for our speakers, Angelica and Roberta. Many thanks for the participants and the questions. And let me thank also my colleague Monica for all the hard work that she's doing with the online course, and for all the communication about the activities. She's really we could not make this course without her. So sincere thanks. Thank you, Monica.
Thank you very much.
Thank you. Bye-bye.
Thank you very much.
Bye. Thank
Nara.
you.
Thanks for the invitation. Thanks everybody for the attention.
Bye.
Bye.
Bye.